Hey friends, if you're interested in the latest immigration news, join me, watch this video, join my live session. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with people all over the United States and in many different countries, helping with various complex immigration matters. Visit us at McBeanLaw.com to learn more. But in tonight's session, or it depends on where you're at, whether it's morning for you. But in this live session, we're going to be talking about two things. Firstly, the U.S. Supreme Court, and I see that folks are joining. Thanks so much for being with me in this session. Let me just go ahead and give you guys a summary of what we're going to cover in tonight's session. Say hello below. Okay, so here's what we're going to do tonight, friends. We're going to talk about the Supreme Court ruling that came out earlier this week that everyone is talking about. News came out that the Supreme Court ruled against immigrants. We're going to talk about who this applies to and how you can overcome this, okay, if you're impacted by the Supreme Court ruling, Sanchez v. Mayorkas. And then secondly, we're going to talk about some very exciting updates at USCIS. USCIS had some good news for us this week, so we're going to dive into those updates. But firstly, guys, let's go into the Supreme Court case, just the highlights, okay? Just the highlights of Sanchez versus Mayorkas. And this was a unanimous ruling that came out earlier this week that says that a TPS, and let me zoom in a little bit further here, a TPS recipient or someone with temporary protected status who entered the United States unlawfully is not subject to lawful permanent residency status merely by virtue of that person having TPS, okay? According to the Supreme Court, it says that this section of our law provides that eligibility for LPR status generally requires an admission into the country. Admission, okay, defined to mean the lawful entry of the alien into the United States after inspection and authorization by an immigration officer. And Sanchez, in this case, did not enter the United States lawfully. And let me just scroll to another section here that just gives a little brief overview of what happened in his case. And you may very well find yourself to have similar facts. Okay, so Jose Sanchez, a citizen of El Salvador, who has lived in the United States for more than 2 decades. He entered the country unlawfully in 1997 without inspection and authorization by an immigration officer. Once here, he worked without legal authorization. And in 2001, the government designated El Salvador under the TPS program after a series of devastating earthquakes. Sanchez obtained TPS status that year, and he's held it ever since. And in 2014, he applied for adjustment of status. And USCIS denied his application, and they held that he was ineligible for LPR or lawful permanent residency status because he had not been lawfully admitted to the United States, okay? So in essence, this ruling impacts TPS holders who entered the country without inspection or admission. It does not impact those of you who came into the United States with a visa and you overstayed, okay? Does not impact you. So this decision does not impact all TPS holders. It does not. Only those who entered the United States without inspection and admission. Now, how do you get around this, Latoya? How do you is there a way around this? Because, I want to get my green card in the United States. I don't want to have to, I want to become, although TPS, I have TPS and it's protected me from deportation or removal. What can I do to get my green card? Well, some people are eligible, friends, for a waiver. Some people will have to consular process. And there's a very strict list of requirements that one must meet in order to be eligible for the waiver. Now, our office does these waivers, okay? And so contact us at McBeanLaw.com, set up your appointment, and let's see and analyze your case to see whether you're a good fit for consular processing and these waivers that I'm describing, that I've mentioned briefly in this session. Again, not everyone is eligible for that, okay? So get your case assessed to see whether this is something that can help you. Okay, so that's the first news that came out this week. Guys, I see you're coming on. Thank you so much for being with me as you're joining. Just say something in the comments. Let me know what you think about this decision by the U.S. Supreme Court. Now, let me just jump back on here for a moment and get over into USCIS. USCIS, the immigration office or agency that processes immigration benefits and applications, came out with some news this week that essentially will make it easier for you as you're going through their process. There are certain things that they've gotten rid of that were under the Trump years that they've rescinded, and we're going to talk about those things. And then there's some other things going on that will make it a smoother process for you as you go through their agency. So let's just get into that. Okay, so this is USCIS's news page, and let's talk about the first announcement here. USCIS announces lockbox filing flexibilities. Okay, so according to USCIS, let me make sure that you guys can view this screen fully here. So according to USCIS, they realized after AILA, the American Immigration Lawyers Association, challenged them on some things. They came out with this policy that says that they're going to offer some people more flexibilities, okay? It says here that USCIS will offer filing flexibilities to provide relief to certain applicants and petitioners impacted by delays at a USCIS lockbox. And the flexibility applies only to petitions and applications filed at a lockbox, not at a service center or a field office. And the temporary flexibilities are effective for 60 days from June 10th until August 9th, 2021. And the first policy says this: if you submitted a application or a benefit request to a USCIS lockbox between October 1st, 2020 and April 1st, 2021, and the request was rejected during that time frame solely due to a filing fee payment that expired while the benefit request was awaiting processing. USCIS says that you may resubmit the request with a new fee payment. If USCIS concurs that it has rejected the benefit request because of the delay, USCIS will deem the request to have been received on the initial filing date it was received and waive the $30 dishonored check fee. And so basically what this is saying is if you had filed your petition between that time period and you used a check, for example, you used a check to pay the filing fee, and because of delays at the USCIS lockbox, your check expired and they rejected your filing. So they're telling you that you could refile, resubmit your money, and if they agree that they made the mistake, they will not, they will waive the $30 check fee policy or penalty. That's number one. Number two is that they're going to allow, now this is for those who are concerned about the fact that they filed and they were under a certain age, and during the time of their filing, there were significant delays at USCIS lockbox. They aged out. Okay, and they're no longer eligible for that benefit. USCIS is saying that if that did happen, then you're going to need to resubmit and inform them of the fact that they caused this delay and you aged out. And so basically what they're going to do, and I'm going to read to you guys the sentence here, they're basically going to, if they agree with you, they're going to consider your application to have been received on the date of the initial benefit. When you requested the benefit, they're going to consider that earlier date from your first filing, in essence. So those are some good things for those of you who have been impacted by delays recently. And then they came out with some more exciting news, actually. Let's go into some of the policy changes that they came out with recently that I think are actually really good news, including rescinding some things that Trump put into place. Okay, so they made some updates to their policy manual with respect to expedited processing. Everyone wants to get their case expedited these days, but of course, you know that they don't approve quite a bit of these requests to expedite the case. If you go on their website, under expedited processing, they tell you exactly what you need to do in order to get the case expedited and approved. And I have an old video out there on my channel on how to do this. So go back and search my channel for how to expedite your case at USCIS. But in any event, they updated their policy to clarify some things and to indicate that nonprofit organizations who requested expedited processing in furtherance of a cultural or social interest of the United States, they may request expedited processing for an applicant, even if premium processing is available for the benefit. And then this is the policy that I'm most excited about, guys, the request for evidence and notices of intent to deny. Remember, under the Trump years, there was a memo that was issued that said that immigration officers may deny your application or your petition without first issuing an RFE, a request for additional evidence, or a notice of intent to deny. Well, the government now has rescinded that memo, and they will give you an opportunity to explain yourself and to clear some things up before they deny your case. So that's really good news. And then the last piece that's really good news is the fact that employment authorization documents, your EAD, for those of you who have applied for adjustment of status, the government typically gives you a 1-year term on your EAD. Now they're going to do 2 years. So the 2-year will apply to those of you who are applying initially for the very first time, as well as those of you who are applying for the renewal. So that's really good news. So that was a lot, right? That was a lot, but I wanted you guys to be aware of all that's going on at USCIS. And okay, and then lastly, guys, before I go, because this is getting a little long, before I go, I do want to mention and remind you guys that you should get your consultation scheduled with us online virtually. We do everything virtual at my office. So go to McBeanlaw.com to book your consultation. And also for those of you who need further immigration help on your own, okay, if you're doing some things on your own, just a reminder that I have some really good courses online. Let's see if I could get this pulled up here to show you. Give me a second here. My website, for those of you who don't know, it's latoyamcbean.mykajabi.com. And when you go to this website, guys, and you click on my view courses, that's where you're going to see the courses that I have out there for you. If my computer will cooperate. Okay, there we go. Okay, so just scroll through and you'll see that I have various courses out there ranging from $19 to $497, all right? And so you wanna check this out on my website at latoyamcbean.mykajabi.com and get on my email list as well, because when I have new courses that are available, I will be sure to update you guys about that. Guys, thank you so much for being with me tonight. I know it is Saturday. If you have not yet subscribed to my channel, subscribe right now and hit the notification bell so that you won't miss any of my videos each week. Thanks so much again for being with me, and follow me on Instagram so that you can get more behind the scenes look and information from me on Instagram. Guys, thanks so much, and I will see you in the next one. Bye-bye.